My name's Charlotte Geesin, Head of Employment Law, Business Immigration at Howarths, and welcome to All Things Flexible webinar. Flexible working requests, predominantly, but in addition to talking you through the legal and best practice principles in respect of those employee requests, also going to be talking about the flexible furlough scheme and how employees can request flexible working locations. So just before I launch into everything, if I could just please do a very quick sound check. If you can hear me, if you could just open up the Q&A box, and if a couple of you could just say, yes, we could hear you, that would be great. Hey, wonderful. Perfect. Okie doke. Oh, lovely. Great. If any of you are having sound issues, then on that basis, I'm going to assume that they're at your end. But my colleague Louise is sat in the background. So if you do have any problems at any point, or if the connection drops at all, just type into that Q&A box, and we'll do our best to see you right as soon as we possibly can. This webinar scheduled for sort of 30 minutes or so. For those of you who know me, timing not my strong point, may run over by a couple of minutes, but please do bear with me if you can. Wouldn't want you to sort of miss out at the back end of the session. It is being recorded though, so you will be able to access the session should you wish to watch it again at any point, or should you end up missing any of it at any point. I will be taking live Q&As during the session, so feel free to pop me any questions that you may have in that Q&A box. I'll do my best to answer as many as I can, but if I can't get round to them, fear not. I will be prepping a full Q&A sheet after this session, which will be sent directly to you by way of follow-up. The questions that have already come in, thank you. I've done my best to answer those within the body of this session, so keep your ear out. But if you obviously have anything else that you wish to discuss, either just pop it in the Q&A or let me know by way of follow-up after this session. Right, okay, so all things flexible then. Some people say the future is bright, some people have said it's orange in the past, but I say that quite simply, when it comes to business, the future is flexible. Simple as that. Whatever your views currently are on flexible working practices, there's no escaping the fact, I don't think, that they are here to stay. Employers and businesses will be managing the fallout from the COVID pandemic for some time now, I think, and socially distant practices therefore will be with us for a while, and obviously those will force a lot of employers to implement more flexible working practices. However, in the sort of post-COVID world, sounds quite apocalyptic, that, I think, and however that may look, I think that it seems likely many employees actually will want, expect and possibly need flexible working practices, and on that basis, I think employers should start perhaps giving consideration now to new ways in which they can adapt their working practices in order to meet with that sort of shift in expectation that's probably coming from the nation's workforce. Like I say, during this session, I'm going to talk to you about all things flexible, flexible furlough scheme, flexible working and home working. In respect of the home working side of things, I'm going to try and hopefully give you some food for thought and some practical tips in terms of those things that you need to start perhaps thinking about now if home working is something that you either expect your employees to ask for going forward, or if it's something that actually you're looking at implementing yourselves. Just I think at this juncture, it's sort of worth sort of noting that when it comes to the flexible future, there isn't going to be a one-size-fits-all approach. You know, each business will be different in terms of its needs, its desires, as will each business's employees. But what I would just say is that there's always a way with employment law. And anything that you need, anything that you're proposing, anything that you're thinking about, if you want to discuss that with us at any time, then you're more than free to do so. And we'll obviously work with you as closely as possible to sort of put into place whatever it is you're thinking you may want your operations and your sort of workforce to look like as we sort of move through and hopefully out of this pandemic. Just another point before I get into the meat of things. When I was prepping this session, I must have written the word flexible about 85 times, and it's weird what lockdown does to your brain, because all day yesterday all I could think of was that old Mr. Bean clip when he's sat on a park bench making his sandwich in silence, and at the end he gets out his credit card, his flexible friend, to butter his sandwich. Hopefully some of you out there will know what I'm talking about, but if not, at least all of you now know exactly what runs through my head when I'm prepping something like this. Okay, so flexible furlough, the latest. About a week and a half ago now, HMRC released details of the flexible furlough scheme, which is due to start on the 1st of July. Under this scheme, obviously, employees are no longer going to have to be prevented from doing work for their employers in order for the employer to make a successful grant claim under the CJRS. Under the new scheme, employees will be allowed to work part-time with their employers paying them in full for any work done, but then being able to be furloughed for any downtime, with the employer making a claim under the JRS for furlough pay in the sort of way that we're all accustomed to now. It might be sort of useful to note at this stage that if you are looking at utilising the flexible furlough scheme, you don't have to only look at working days. The flexible furlough scheme is actually it's actually going to allow employers to place employees on flexible furlough for part days or even hours. So you can quite legitimately have an employee who's contracted to work 9 till 5 Monday to Friday, but you may turn around and say, actually, we only need you for mornings. So you can have them work for the mornings and then they can be furloughed for the afternoons. Similarly, if you only want people to work 2 out of 5 days, then that's okay as well. In some respects, the flexible furlough scheme is pretty straightforward. The primary tenet of the scheme is, like I say, the allowing of furloughed employees to work whilst furloughed. But in others, as with pretty much everything furlough related, it's horribly complicated. The rules have changed or have been added to in respect of how you claim for payments, and also the amount of information that you have to submit to HMRC has increased. The guidance on the flexible furlough scheme is all over the place. There's 3 or 4 different sort of articles or publications where details are set out, and kudos from me to anyone who has read through all of that guidance to date. I think for the purposes of this session, perhaps one of the sort of trickiest questions is in terms of how flexible can an employer expect an employee to be under this new scheme. So, for example, can an employer simply say to an employee, right, flexible furlough, you now have to be ready and willing to work, essentially, and essentially be at my beck and call during normal working hours, therefore giving the employer complete freedom to sort of dictate when the employee works and when they don't work? Or is it a case of the employer being under a requirement to give very specific details about what the flexible furlough scheme is going to look like, as opposed to that more general kind of, right, we can call you back to work at any time? The guidance is a little bit iffy in that respect. It doesn't offer huge clarity, but I think the answer probably lies somewhere in the middle. Employees are obviously contractually obliged to be available to work when their employer has work to do, and therefore, in theory, if a business wants to look at bringing people back sporadically, this will be totally fine. However, these are obviously unprecedented times, and for the most part, employees are having to juggle a number of plates. They're juggling work commitments, childcare commitments, maybe they've been poorly. They may live with people who've been poorly, or they may have caring responsibilities. And so an employer must still continue to take these into account when looking at the viability, the reasonableness of any sort of flexible furlough arrangement that it wants to put in place. It's not going to be any good, for example, for an employer to force an employee with childcare responsibilities back to work under the flexible furlough scheme when they can't. And an employer who takes that stance will likely come under sort of heavy fire from a tribunal in the event that an employee seeks to challenge any decision in that regard. Just whilst on the childcare point, obviously it's massively contentious for a lot of employers and employees alike. And as it stands, there's no sort of specific guidance on how to deal with the sort of childcare issue in practice. Each case will turn obviously on its own facts, and what's reasonable for one employer and one employee will be very different to another case. But I think for now, if you sort of take away from this session the fact that there is a very sort of distinct importance about considering each case on its own merits, that will be sort of good enough, I think for now. There have been a few specific questions in advance of this session about childcare and furlough and the flexible furlough arrangements. And I think for those of you who have tabled those questions, it might be better for us to have a chat. So please feel free to get in touch with me after this session at any point to sort of run through those. Couple of questions. Furlough hours paid on furlough rate or full pay? Good question. So under the flexible furlough scheme, any hours which the employee doesn't work and the employer therefore will claim furlough pay for are paid at the rate of furlough pay. So 80% for now. You don't have to pay full pay. You can choose to pay full pay, just like you've been able to choose to pay full pay during the furlough period, but there's certainly an obligation on you to do that. Question on the childcare point. Supposing school is available but parents choose not to send them back. Yeah, well, it's these types of questions which sort of complicate the issue of flexible furlough and childcare, because actually what we would probably need to look at doing in that instance is finding out why the employer is reluctant to send the children back to school, to look at what alternative arrangements they may have at their disposal in terms of childcare, and then kind of almost build in a bit of a picture around that to sort of then work out what options the employer then has and what options are reasonable in terms of dictating the employee's return to work. In terms of the operational side of the flexible furlough scheme, sort of moving away from the sort of problematic reasonableness type of considerations that an employer needs to have, for the most part, the flexible furlough scheme is the same as the furlough scheme that we've all known to love. But there is a very significant change, and that is in that the minimum 3-week furlough period is going to be removed as of the 1st of July. So there is no longer going to be a requirement for an employee to be furloughed or flexibly furloughed for 3 weeks in order for the employer to be able to make a successful claim under the job retention scheme. Like it says on the tin, the flexible furlough scheme is a flexible working arrangement. So, and the government obviously want as many employers to take as much benefit from the scheme as they possibly can, hence the removal of the 3-week furlough period. That said, if you have furloughed people now, so between the 10th of June and the 30th of June, then you must still ensure that they are furloughed for the full 3 weeks, even if it takes them past the 1st of July. If you don't ensure that they're fully furloughed for at least 3 weeks, then your claim for the grant payment will fail. Once that 3-week period has passed, though, you will then be able to place any employees who sort of fall into that category on flexible furlough in exactly the same way as anybody else. Some other headline points with regards to the flexible furlough scheme that employers should be aware of, I think, is that any requirement for flexible furlough needs to be agreed and recorded in writing with the employee. This is a very important point, actually, for many reasons, but not least because the government have indicated that if you don't have a written agreement in place and you can't evidence that your employees agreed to it, they won't pay you this time around. For those of you who are clients, hopefully you will have seen today's update pop through into your email inbox about a flexible furlough agreement. If you haven't, check it out and have a look on your client portal, because now you will find a template flexible furlough agreement with some guidance notes that you can start implementing with your employees. Just a quick question: can an employee who is returned to work be put on flexible furlough? Yeah, that's fine, as long as they have been furloughed previously, so before the 30th of July for the full 3-week period. Any employee who has previously been furloughed for at least 3 weeks is eligible to be flexibly furloughed come the 1st of July. Employees can also be flexibly furloughed more than once. So it's not like you have to keep them on flexible furlough. You can flexibly furlough them, then put them back on full furlough, because that remains an option. Or you can bring them back to work for a period of time. You can mix and match amongst the three. Like I say, the government is trying here to give as much flexibility as possible to employers. So it's quite happy for the sort of employer to sort of pick and choose the best bits, if you like, in terms of them getting their operational procedures right. The holiday rules, they will remain the same during the flexible furlough scheme. Holidays will still accrue, and from the 1st of July, employers will still be able to compel employees to take annual leave, provided they give requisite notice, including bank holidays. Where an employee isn't compelled to give annual leave, to take annual leave rather, then the rollover provisions are also there in the background as well. And we know obviously that employees who are prevented from being able to take annual leave, or where it was not reasonably practicable for that employee to have taken annual leave, the leave can then be rolled over up to a maximum of 20 days across the next 2 leave years. That sort of concludes the sort of flexible furlough scheme update bit. But obviously, if you've got any questions following this session, then do not hesitate to get in touch. I suppose just as a final point, we aren't expecting any further guidance about the flexible furlough scheme. However, it seems likely that we will get odd bits and pieces through from the government as the scheme starts kicking in post 1st of July, and as you know, the HMRC start to identify some teething areas. And obviously, as soon as anything like that comes through, we'll update you accordingly and let you know what you need to be doing. In terms then of flexible working, in my previous webinar, if any of you joined me for that, I spoke to you about how an employer can vary an employee's terms and conditions of employment. And I think a good way of looking at the notion of flexible working in the legal sense is that it is the way in which an employee, as opposed to an employer, can lead on that variation process. I think as we move out of the COVID pandemic, it seems likely that there will be an increased number of flexible working requests made from employees right across the board for many different reasons. Some employees, for example, might have reassessed their priorities whilst they've been off and want to reduce their working hours to spend more time at home. And others may realise that they actually need more flexibility in order to manage things like childcare. But in any event, as the law stands at present, an employee can actually make a flexible working request for any reason. It doesn't have to be COVID related, it doesn't have to relate to childcare. The right to request flexible working, it's been around for a long time, and the current process has been established in law since June 2014. The scheme, for those of you interested, is set out in sections 80F to 80I of the Employment Rights Act, and they are supported, the sections are supported by the Flexible Working Regulations 2014. If any of you want to read them and talk to me about them, then that's fine. I'm happy to have chats about legislation with people if they so wish. But if you're not perhaps as boring as me, I don't know, then that's fine. But what I would strongly advise you to read is are the two supporting ACAS documents. Now, there is a statutory code of practice with regards to flexible working requests that ACAS have published, and also a guide on flexible working. The reason why I say it's important for you to read these is because if you are faced with a flexible working request from your employee and you then end up in a dispute about it and you then end up in tribunal, a tribunal is duty bound to look at how well the employer adhered to that ACAS guidance. So it's a bit like your ACAS code on disciplinaries and grievances in sort of disciplinary situations, unfair dismissal cases. In that situation, the tribunal is obviously obliged to look at how well the employer adhered to that code when dismissing someone or dealing with their grievance. And obviously in that situation, the tribunal can even uplift compensatory awards to take account of any unreasonable failures. So do have a look at those. They're easily accessible via the ACAS website because they'll serve you right, I think, going forward. The current flexible working request scheme allows employees with at least 26 weeks of continuous employment to make one flexible working request in any 12-month period for any reason. The employee triggers the flexible working procedure by making a written request to their employer, who then has a 3-month window to basically consider the request, discuss it with the employee where appropriate, and to notify the employee of the outcome. The employer must deal with any flexible working requests in a reasonable manner, but the employer isn't obliged to grant the flexible working request where it essentially has a decent business case for not doing so. There are 8 statutory grounds which an employer can rely on to refuse a flexible working request, and provided that an employer can show that it is able to justify a refusal on one or more of those 8 grounds, then usually there aren't too many issues sort of ahead for that employer. If an employer doesn't act reasonably, either in terms of dealing with the flexible working request or in terms of refusing any flexible working request, then the employee can complain to an employment tribunal. And the biggest risk area, generally speaking, when it comes to flexible working requests is unlawful discrimination. I said a couple of minutes ago that an employee can essentially make a flexible working request for any reason, and that's right. But if we look at the strict sort of guidance or rights under the legislation and the ACAS provisions, what that actually says is that an eligible employee can request a change to their employment terms if the change relates to the hours they work, the times when they work, or the change the location at which they carry out that work. Now, if you sort of think about that, actually, under those 3 very simple categories of request, there are a huge range of possible working patterns. The scope of the legislation effectively includes applications for part-time working, full-time working, annualised hours, compressed hours, flexi time, home working, job sharing, self-rotoring, shift working, staggered hours, term time working. The list is endless, really. And in fact, there are very few limits as to what an employee could actually request by way of variation. So perhaps do be aware of this sort of going forward. Like I say, there's no sort of limit in terms of what your employee might sort of present to you as a desirable option for working going forward. In terms of the employee actually making the request then, there is a prescribed form that the employee must follow. And amongst other things, any request needs to be in writing, and it needs to be very specific in terms of the change that the employee is seeking from you. And quite interestingly, what the legislation also requires is for that employee to set out how it thinks their proposal may impact on you, and also how they think you might be able to deal with any such impact. Now, I quite like that because what it means in practice is that when you end up discussing the flexible working request with your employee, if you have to sort of maybe express a little bit of reticence about accepting the request, or you want to have a conversation about the sort of commercial viability of the request that's being made, that should already be in the employee's mind in part. I mean, they're not business owners, then they're not going to know necessarily the bigger picture in terms of your wider working arrangements and operational procedures, but they kind of already get it. And in sort of my experience, what that sort of requirement of the legislation does is make it easier for you to have a sensible conversation with an employee about a flexible working request. It kind of removes the emotion that can be attached to things like this right from the outset, because the employee is forced to think about it in part from your perspective. When you get a request, like I say, you have to deal with it in a reasonable manner. Now, reasonable, it means so much, but it means so little, and it's a word obviously that we come across all the time in employment law. But for the purposes of flexible working, it's basically about conversing with your employee, discussing any concerns that you have, and ultimately trying to find a way that works, but which works for both parties. It also means properly thinking about the employee's own situation as well. So if a flexible working request, for example, is driven by childcare needs, don't just dismiss that fact. Think about what those childcare needs are. And like I said a couple of minutes ago, explore around the issue that the employee is putting to you. So like I say, is the childcare a problem every day of the week, or is it just a couple of days a week? Are there any sort of alternative childcare arrangements which can be put in place? Are you perhaps willing to allow the employee to deviate from their normal 9-5 working hours to help accommodate the childcare needs during the day? It's stuff like that are sort of taking a more rounded, holistic approach, which enables you to show ultimately that you've been as reasonable as possible when thinking about each individual's request. As well as sort of conversing with the employee about the flexible working request, you're also, like I said again previously, obliged to notify the employee of your decision within the 3-month window, although I'd strongly advise you to try and get this boxed off well before the expiration of 3 months. And if you're going to refuse the request, you must do so on one of the 8 statutory grounds. I won't go through all those grounds now, but they're readily accessible on the internet, or if you obviously want to discuss those with me in further detail, then you're more than welcome to do so. But generally speaking, they're all pretty broad in scope, and they refer to things like cost burden, or an inability to reorganise work amongst existing staff, or concerns about detrimental impacts on quality or performance. They're not narrow and very specific. They're broad, and they are kind of there to allow an employer to sort of, as long as they have a genuine reasonable business case for refusing a flexible working request, they allow an employer to kind of rely on the statutory grounds in order to justify any refusal pretty readily. Flexible working legislation, in my view, is actually one of those sort of areas which is quite favourable to employers, actually. It doesn't always seem like that's the case, but in this instance, I think it genuinely is. Like I say, the grounds for refusal are nicely broad, and ultimately sort of allow you to shape your position in respect of the request around your business operational needs. If you are able to make an agreement with your employee for flexible working, then fantastic. If you do it, though, it is a permanent variation to an employee's terms and conditions, and you are therefore obliged to record that variation in writing. You're obliged to issue what's known as a Section 4 statement following any successful flexible working request, which is essentially just a written statement of the changes to the employee's terms and conditions. And following the legislation that was brought in April this year, you'll also be required to issue an updated Section 1 statement setting out some key terms of employment. There's no immediate requirement to issue a brand new contract if you accept a flexible working request. In most instances, it's perfectly acceptable just to issue a side letter that deals with those Section 4 and Section 1 requirements, but it's entirely up to you. Some employers prefer to issue a new contract, some don't. I don't generally have a preference either way. If, going back to a refusal, if you are going to refuse an employee's flexible working request, another sort of really interesting point about the flexible working legislation is that it doesn't actually give an employee a statutory right to appeal against a refusal. So one approach that you could take is to sort of refuse any appeals. You know, you've made your decision and that's what it is, and the employee doesn't actually have a right to do so. However, the ACAS codes, which obviously we know the tribunals will take into account when assessing an employer's reasonableness in terms of process, strongly advises employers to do so. And that would certainly be my approach. If you are faced with an appeal from an employee off the back of an unsuccessful flexible working request, it's certainly beneficial to you to at least hear what the employee has to say. Forewarned is forearmed when it comes to anything, you know, potentially litigious. So always give the employee the opportunity, I think. Flexible working policy, there's no requirement to have one, but again, it can be a really useful thing to have, because it can, you know, obviously set out what your procedure is, some grounds perhaps that you will consider when assessing the viability of a flexible working request. And I think as well, having a flexible working policy in place will also sort of help your employees to sort of understand that it is something that you take seriously. So if you do have to refuse a request, sometimes that can be, you know, slightly more palatable for them. In terms of pros and cons, flexible working, depends which way you look at it. There's always pros to things, there's always cons to things. But I think that generally speaking, the biggest advantages of flexible working sort of are in relation to, you know, like your employee relations, I suppose. They can certainly help promote a happier, loyal, more productive workforce. There's evidence from CIPD, I think, to show that flexible working arrangements can help reduce sick days. And without a doubt, I think particularly with the sort of younger cohort of workers in this country, those who are currently leaving university and entering into the job market, flexible working and work-life balance is high on people's agendas when it comes to where they want to work. So I think there is certainly an argument to say that flexible working can help you to attract talent. From a cost perspective, flexible working can help you to avoid redundancies. And it can also help you to reduce sort of your office overheads. If you've got fewer people going into the office, you don't need as many desks. Hot desking, usually more economical. Cons, I think the biggest con that you sort of come across in practice is you know, one of trust. You know, do we trust our employees to work flexibly if there's an element of homework in there or an element of sort of more fluid hours? Practically speaking, employers could lay themselves open to discrimination claims if they only agree flexible working requests for certain employees over others. And there could be you know, resentment among staff, I suppose, if they haven't had their flexible working requests granted over others. But like I say, pros and cons to everything, and each case will be different. But I think on balance, they're probably pretty good overall, I think. Working from home then. As I say, wherever you currently sit on flexible working, I don't think home working is going away anytime soon. The government obviously still mandating the work from home if you can message, and it's likely, I think, that this will factor heavily in the new normal. The government is currently tabling a proposal to give all employees an automatic right to work from home. That hasn't been sort of confirmed yet, but it seems likely maybe that will be something that comes into play at some point, so do just bear that in mind for future. Whilst there's obviously no statutory right as yet to work from home, there is certainly an obligation on employers under the current COVID secure guidance to make sure employees are safe. So I think, where you can facilitate home working, then you should. Moving sort of out, I suppose, of the COVID crisis, and when we sort of have a bit of control back over our own business operations, if home working is something that you want to look at doing, then like I said at the start, there's a few things really that I think you need to sort of be thinking about now. And I'm just going to run through a couple of headline points that I certainly think are sort of worth bearing in mind at this early stage. Home working policy. That's where you should start. If you are looking at implementing home working or rolling it out at any point across your employee body, a home working policy setting out what your expectations are is a must, I think. For those of you who are clients, there is a home working policy already uploaded to your client portal, so take a look at that. For those of you who aren't clients, if you want to discuss what a home working policy should look like, then by all means feel free to get in touch. As well as sort of having a robust policy document in place, it's really important as well that your contracts of employment are up to speed too. Because if an employee is going to work from home as the new normal, then under their contract, their normal place of work will automatically become their home address. But your paperwork obviously needs to reflect this. I would say that it's worth giving this proper thought, because in the sort of initial stages of sort of paperwork amendment, it's then when you have the greatest opportunity to start building flexibility in for yourselves. So if you need your employees to travel as part of their normal work or come into the office, then you want that bottomed out right from the beginning. You don't want an employee sort of arguing a toss later down the line when they've been working from home and not having to go anywhere for a while, and then you turn around and say, actually, no, we need you to go out and about now. As well as being specific in terms of where an employee must work, an employee's contract also needs to be very clear on when they will work if they're going to be home working. And arguably this is perhaps the most important thing to sort of tie off at the outset. Whether employers like it or not, home working does arguably give employees some slack during the day, but you need to be clear on whether this is something that you're going to tolerate. Are you going to want your employees to work 9-5 with their standard breaks, or are you actually, quite happy for them to sort of, flex their hours during the day as long as the work gets done? There's no right or wrong, but you need to make clear what your expectations are from the very outset, so that if your employee goes rogue, you have good grounds to take disciplinary action against them if that's the way you want to take it, or at least have a conversation. Whatever it is you decide in terms of when an employee must work, bear in mind the working time regulations, which obviously place employees under a maximum 48-hour working limit unless you have an opt-out agreement in place. Too much fluidity in working patterns can obviously blur the home-work boundaries, and there's a risk of an employee doing too much work. I think we normally worry about employees not doing enough work, but there's definitely a sense of home workers having an always-on type mentality. And I think, having homework since March myself, there is a distinct difference between leaving the office and driving home than to just sort of shutting your laptop and shoving it under the settee or whatever until the next working day. It's quite easy to, you know, just log on and just do a little bit more, you know, perhaps when you're watching TV on a night or whatever. But it's your obligation as an employer to promote start and finish times, and also to remind employees to take breaks. There's also perhaps a more contentious point of maybe paying people more if they're working more hours, but also reducing pay if you don't think they are working enough hours or in line with their contract. When it comes to employees who have caring responsibilities, again, be extremely clear what your expectations are. Childcare, obviously, being the biggest one. If you have employees who you know have children around the house during the working day, tell them what you expect of them. If you need childcare to be put in place before they work, tell them that. And also keep on top of it, because if the childcare arrangements fall through, it will affect the home working as well. The onus is on the employee, not you, obviously, to make sure proper arrangements are in place, and for them to communicate to you when any issues do arise, which may impact upon their ability to carry out their jobs in line with your instructions. Practical points, bills, costs. Are you going to be prepared to contribute to your employees' bills while they're home working? That side of things totally up for negotiation. There's no obligation on you to pay bills, but whatever your position is, be clear and be reasonable. Tax as well, tax rebates, very complicated. I am certainly not clever enough to talk to you about tax, but make sure that you speak to your accountants in order to ensure that, you know, any sort of rebates for home workers are properly administered. And also, quite terrifyingly, I found out when I was doing the research for this, is that it could be worth flagging up to any home workers that working from home might actually cause them to default on their mortgage. I didn't know this at all, but apparently home working in some mortgage agreements can constitute sort of operating a business and things like that. So it's important for employees to be aware that they have to take appropriate steps, obviously, to cover themselves. It's not your obligation to do it, should they find that within their mortgage paperwork there's information in there with regards to home working that presents them with a potential problem. Final point, I suppose, and that's make very clear to your employees that your normal policies and procedures will apply. So disciplinary will still apply, grievance will still apply. If they're poorly, they still have to phone you. They can't just sit at home or pretend to work when actually they're hiding under the duvet. If they want a day's holiday, they have to request it. They can't just not work. In terms of social media or IT policies, they all apply to home workers. And if you want to continue or start monitoring your employees' activity either on computers or phones, then tell them. If you want to do that, then you can only monitor computers that you have issued. You cannot access personal property for the purposes of monitoring. That's a breach of the Computer Misuse Act 1990. So do bear that in mind as well. I think hopefully that's giving you, I say, some food for thought in terms of homeworking. But I think those, you know, probably cover the key points. There are obviously, you know, plenty of finer details to sort of go through when you are looking at rolling out a home working arrangement, or indeed a flexible working arrangement. And if when you do that, then each individual's case will be need to look at in isolation. But I hope that helped. And I hope that you enjoyed it. You got an extra 12 minutes. I hope that you're all still with me and haven't logged off. And I also hope that you enjoyed that. Like I say, anything that you need, you know where we are. Please feel free to contact me or any of the team at any time. And yeah, hopefully see you on the next webinar, which will be coming up very shortly. I'll hand you over to my colleague Louise to do the official goodbye. But for now, take care from me.
Thank you, Charlotte, and thank you everyone for attending today. So I just wanted to recap, really, just to finish off from what Charlotte was saying. So in relation to what we've covered today, we will follow up with an email requesting feedback, but also with the recording of the webinar and a blog article in relation to what's being covered. So just keep an eye out for your emails, and that'll be through within within the next 24 to 48 hours maximum. But if you do want to have a read through it or share the video, you're welcome to. I won't go into too much detail because I know we've got some clients and non-clients on here. But if you do want to discuss any extra support we offer, or if you're interested in the service we provide, just give me an email or a call on the details on the screen. I've been having quite a lot of telephone calls and Zoom calls with people just looking to get contracts and handbooks in place, needing furlough letters, things like redundancies, unfortunately, but they need to be done in some instances, and things like health and safety and risk assessments. So if you've got spare 15 minutes, 30 minutes, you want to have a chat, just drop me a line and we can discuss it. And then very finally, if you just keep an eye out on the emails we send through and upcoming social media for upcoming events, we've got a live Q&A on redundancies with Charlotte that you've just seen, who's fantastic, and Gavin, our MD, who are going to be running through that in some detail. There will be a webinar on termination under 2 years service with Wendy Creswell, who's one of our advisors as well. And then very finally, in the coming months, as we roll into July, there'll be a mini-series on redundancies because of what's happening in the world and people needing to start to look at that process. So if you need anything, get in touch. We hope you've enjoyed today, and I'll hopefully see you all on our next event. Thank you.